I
Yeah.
do solemnly swear that I will support and defend the Constitution of the United States, Constitution of the State of Hawaii, and the Charter of the County of Kauai, and that I will faithfully discharge my duties as a member of the Charter Review Commission of the County of Kauai to the best of my ability. Congratulations. Here we go.
Sign away.
Sign away.
Okay, it's 4 o'clock. I call this meeting of the Kauai County Charter Review Commission to order. I'll note that we have a quorum. I will note that Marissa Sandblom, who was nominated but not yet confirmed, is in the audience, and she will not be allowed to participate in today's session, but we hope to have her soon.
Oh, shucks.
You have before you on the agenda well, it's not on the agenda. Are there any changes to the agenda before we proceed? Hearing none, the agenda stands approved as submitted. We have the minutes of the September 25, 2017 meeting. I've reviewed them. They look good to me. Has anybody else got any heartache about those minutes?
Move to approve.
Second.
Moved and seconded to approve the minutes of September 25. Any discussion? If not, all those in favor say aye.
Aye.
Opposed? Hearing none, the minutes stand approved. Moving immediately into the business of the day. First item is CRC 2017-03, proposed charter amendment to remove Article 19 relating to the public defender. I will note that this section was placed into the charter early on, but was made moot by the 1968 Constitutional Convention and the legislature. I don't know if it was Constitutional Convention or the legislature, but there is now a state provision that the state, in the Hawaii Revised Statutes, that the state handles public defender duties, so this section is no longer appropriate in the council, so the proposal is to remove it. Mr. County Attorney, did you want to address the commission with regard to that? State your name if you would, and give us your thoughts.
Aloha, for the record, Matia Trask, County Attorney. No, I don't have anything more to add. Honorable Chair Tim Brugengate is correct. The other day, I was looking through the Constitution for another issue, and like most things in my legal research, I stumbled upon something else that was relevant. So I have a copy. If any of you would like to see it, I can show you the section, but that's what it says.
Discussion, well, are there any other members, any questions for the county attorney? So the measure in the charter provides for the county to be able to create an Office of Public Defender, which to my knowledge it never has, and it's now been made. Questions for Mauna Kea? Hearing none, thank you. Members of the public, anyone care to come up and discuss this item? Hearing none. Members, discussion on the proposal to remove the reference to the public defender in the county charter.
Mr. Chairman,
Sir.
I'm in total agreement with this proposal, and I would support this proposal.
Thank you. So our process normally has been to consider it. If we make a recommendation for a charter change, then it goes to the attorney's office for a check as to the appropriateness of the language or development, if necessary, of the language to create a charter amendment, and then it comes back to the Charter Commission, and in a public meeting we we vote on it one more time, so there are multiple opportunities. This is the first time it's come up. It doesn't sound like there are any issues. But, does anybody else have any questions or?
Just curious, where did it come up from? Where was proposed by committee, by council, by?
This was one of several items that the Boards and Commissions Office raised to me, and I put it on the agenda. So I was the one who put it on the agenda, looking at measures in the charter which no longer have any particular relevance. I've been aware of this one for a long time, and in my days as a reporter, I always wondered what this was doing in here, because there's already a state office of the public defender.
Okay, just curious.
It's just a matter of housekeeping and getting it out.
I think that's a reasonable.
Do you need a motion to have it moved out to the
I do.
clerk's office? I still move.
Second.
Move to send this to the is that Paula, is that we'll send it to the attorney for review, the appropriate action. Okay, moved and seconded to move it to the county attorney's office for review and development of the appropriate language, after which it'll come back to the board for further consideration. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Opposed? So enacted. Now, on the next item, another issue that's similar is relating to the Electric Power Authority. And since I am an elected member of the board of KIUC, and there could be a consideration, could be a conflict at some point, I'm going to recuse myself, and for this purpose, turn the gavel over to my associate, the vice chair.
Okay, Mr. Chairman, I would want to propose to delete the Article 30 relating to the Electric Power Authority in its entirety, as KIUC was established not long after this was passed, so this is more like a house cleaning measure. Therefore, we don't need this in the charter anymore. So that's why I propose it. So it's similar to the previous proposal. And Mauna Kea, Mr. County Attorney, do you have any comments?
For the record, Mauna Kea Trask County Attorney, no, I don't. The County Attorney's Office generally would support any kind of house cleaning measures, just to clean up the charter, get rid of any unnecessary provisions. It's definitely not an endorsement on whether or not there should be an electric power authority. It's just that there is a KIUC, and therefore this was never acted upon. It'll make it easier, I think, for the public to consume and understand without a bunch of things that don't exist. And of course, now that this is a standing commission, you're very responsive, you can get to these things. This body can get to these things anytime it wants.
Any members have questions for Mauna Kea?
I think just more for clarification, relating to the Electric Power Authority, meaning that it was supposed to have established, what was the context for this article?
Yeah, I think
Just for my own edification.
my understanding is before there was Kauai Electric, and that was part of a larger organization. And then at this time, there was one movement. There was a question as to what to do with that, and ultimately it became a cooperative, and that's KIUC now. This was another option, but it was never, enacted. It was never pursued. I think it's because the co-op, the people of Kauai decided to do a co-op and become essentially shareholders in their own electric utility. That's how I understand it.
Were they trying to make it as a government entity?
Yeah, that would have made.
That's what it was.
Yeah, it would have made it a county department essentially.
Oh, really?
Or like,
Because There was a lot of intervention via my memory on that issue.
Thank you.
Okay, so members, can we refer this also to the county attorney for review?
So moved.
Second.
Moved and seconded to refer to the county attorney for review. All those in favor say aye.
Aye.
Motion carried.
Thank you, Vice Chair Watanabe. The next order of business is a proposal to remove the Zoning Board of Appeals, which is something that was just approved by the electorate last year. Mr. County Attorney.
Aloha for the
So
record.
this is, I think, probably confusing to a lot of us because this item was proposed to the Charter Review Commission by the Planning Director. The Planning Director, the Charter Review Commission approved the establishment of a Board of Appeals, which would handle some of the appeals that the Planning Commission is now handling, but doesn't have time to handle. And it's my understanding that the Planning Department, as a result, has had to spend a lot of money hiring hearings officers to handle appeals. So this was established, but nobody was willing to take a position on this board because it would potentially take so much time. With that preface, Monica, you want to take over?
So thank you. This chair is correct. So essentially the Zoning Board of Appeals question came up because the Planning Department and the Planning Commission were concerned that they were becoming really burdened with a lot of the land use and planning enforcement, specifically TVRs, SMA permits, use permits, all these types of issues. And I think, and then they were getting concerned also too because they were spending a lot of money on, what they feel is a lot of money on hearings officers to hear these cases. And the thought was, well, to look into another ways to solve this problem. And ultimately, the record looks like they decided to follow what City and County of Honolulu do, which they have a Zoning Board of Appeals. And they hear appeals from decisions of the director in certain cases. However, I think what I've learned since being here in the county is that it's rare that you can improve, and this isn't meant to be a criticism on anybody. I think that we always got to look at possibilities to solve problems in the best and most economical way to do these things. However, it's become clear to me, working in county for nearly 10 years, that government is rarely made more efficient by increasing it. And usually when you change the system to solve a problem, you just create other problems. That's just a matter of fact. It's like this, which systems happens with systems. And so the three main concerns were time-consuming due process hearings, hearings officer expenses, and then burdening the planning commission. Any of you who attend planning commission meetings or watch them on television, you know they go very long. You're taking time out of, well-meaning volunteers. They meet twice a month, and it can go on. These issues, and even applicants are having a hard time coming back again and again. The public is getting difficult. They want to come in for one issue. The agenda will be stretched for hours until they can get to their, it's a problem to deal with. But since enacting the Zoning Board of Appeals, it really hasn't done anything. In speaking with the Office of Boards and Commissions and helping them within our role to try to effectuate the charter, no one is willing to do this. It's a very difficult, highly technical board. So you have to act as judges, essentially. And so you're going to have to do a lot of due process things. You have to make really hard calls. You're going to have to affect people's lives. And so you don't see a lot of people knocking down the doors for any commission, but you definitely don't see any for the Zoning Board of Appeals. Also too, I think, so you were having a difficult time, we can't fill it. The concerns regarding the the timeliness of hearings, as far as them taking a long time, we don't think that they're a product of the system, but they're actually a product of constitutional due process. And so, although county structure, I think, correlates with the time-consuming hearings process, it doesn't cause it. Ultimately, you're dealing with taking away people's property rights or regulating property under the police power. So that will always take time, and it'll take a lot of time. So having a zoning board of appeals isn't going to solve that. It's just going to take longer, not for the planning commission, but for another board. Let's see. So again, going back to the problems with the timeliness, so the time commitment, we see to actually deal with a hearing, twice a month is not going to be enough. We're currently there's 14 contested cases before the planning commission for various types of TVR or bed and breakfast use permit applications. And just to give you an idea, we're litigating one in particular. So a hearings officer was assigned to that case on or about June 30th, 2015. This is a matter of public record, so there's no problem. In that case alone, there was approximately 6 pre-hearing conferences, and they were held, and that's just about evidence, order of witnesses, all this type of stuff. They were held from August 2015 to March 2016. Thereafter, the hearings on the merits of that case began on March 15, 2016, and there were 5 more hearings. April 18th, July 14th and 15th, August 16th, and August 30th. At that point, an issue came up via motion. That motion stayed the hearing on the merits in that case, and that current motion is before the Planning Commission. And so we have been in hearing effectively in that case for nearly 2 years. We've only met 6 times. And so I don't see how you can solve this timeliness by going instead of one hearings officer who is a licensed attorney that knows how to deal with these things significantly. There's thousands of pages of evidence, or let's say hundreds of pages of evidence in that case. And what took them 3 years and over 6 hearings will not be able to be done by a board of volunteers twice a month. You're going to have to meet at least 8 hours a day, 2 weeks a month, just to get through, just to do it, I think, reasonably. And we have to think anything less will not solve the problem. We have to address the problem. So that's the reality. And finally, since this, I've been trying to learn more about how the city and county of Honolulu deals with their planning process and their zoning. And I've just in reading their charter and looking at the materials online, they do have a fundamentally different zoning process. So in city and county, there's all different types of permits. And in Kauai, basically, the planning director receives permit applications and makes a decision. Thereafter, if you don't like his or her decision, you appeal to the planning commission. Planning commission goes through the hearing, they make a decision, and then it goes to court, depending. There's provisions for the general plan, but that's not really what we're talking about. Whereas in city and county of Honolulu, certain permits are decided by the planning director, but certain permits are decided actually by the county council or the city council. And so, the permits that are decided on by the city council include interim plan development transit permits, plan development resort permits and apartments in Waikiki, plan review use permits, special management area use permits, and zone change permits. So in that case, those wouldn't go to the planning commission for appeal or anything like that. You'd have to go to court thereafter. And so I think that although it's always good to look how other counties do it within the state, it likely was a false analogy to try to say what works in Honolulu is going to work in Kauai without acknowledging that the entire system is the same, or that we're going to have to do fundamental changes to our entire governmental process, which will in effect become Honolulu's process, which I don't think is what the voters necessarily wanted. And so at this point, like how Chair Tim Brugengate said, although I think from legal technical perspective and as a practitioner, the zoning board of appeals is likely will never get off the ground just because it'll be too difficult to effectuate. There may be some merits to it, and I don't want to look like I'm against due process here. I don't want to look like I'm trying to stop what the voters wanted to do. I don't know if the voters fully appreciated what was trying to be done. I know that a lot of this happened right before election last year, and it was very well intentioned. But nonetheless, these are real problems, and we're presenting this idea to you. I think we probably should get rid of it. But I don't want to look like I'm trying to wield a heavy hand or anything like that, so that understood. That's all I have to say.
Questions for the county attorney?
So I missed the point. What process do they use now then? Just working with one individual in the planning commission?
So what the planning commission does is, if it's, and I've seen it a bunch of ways, so let's say the director makes a determination, usually it's an adverse to the applicant, so you'll file a permit application and the director will deny it. So you're entitled to appeal that to the commission. So you ask your commission, I don't agree, I want to contest the case. Thereafter, the commission, if it's relatively basic, they handle it. I've seen them handle it. In other cases, if it's a lot of attorneys involved or it's a technical issue, they will procure a hearings officer. And the rules provide for it. So then they make their decision to get the hearings officer. It then goes to the hearings officer. The hearings officer conducts the hearing, does all evidence, receives all testimony. The hearings officer then writes the proposed findings of fact, conclusions of law, and decision order. That gets delivered back to the planning commission. The planning commission decides whether or not to accept it, amend it, or deny it.
So there is a process in place of this?
Exactly, yeah. And it's been the same process since the 70s.
And nobody has said anything about why we have not implemented this amendment?
The zoning board of appeals just happened last year, and they've been trying, the boards and commissions have been trying to fill it. But when we explain to people what it's going to entail, they politely decline. And Paula's here. She is the one who has to make the phone calls.
Well, I just thought that it was just amended, so,
Yeah.
you know, whenever that happens, it's so hard to get rid of it the next election.
Yeah, what they're talking about, you know, our commission meets hour and a half, 2 hours once a month. That commission, they're talking about 20 hours a week.
Yeah, I can see that.
So it's basically, you can't work and be on that commission.
You have to have the technical skills. have
Well,
to
you can
have
learn the
some
technical
ability.
skills, I would think, but yeah,
But you know how hard it is to remove
yeah.
something that just passed without even practicing.
So
I
further
mean,
questions?
I'm not saying, you know, but it did pass.
Yeah, no, I've tried actually myself. I've asked Warren Perry and now retired Judge Senda, and they just laughed at me. And they would do it with you good.
So, any further questions? Thank you, Mauna Kea. Any members of the public? Yeah. We'll come up after.
Felicia Cowden for the record, and I support the removal of this. And I just want to point out for the record that this was not citizen initiated. It was completely initiated within this room. Very little bit of testimony came from citizens to create this. I think people voted yes for it because any of the information that went out with the last group of ballot initiatives basically said, vote for it, it's a good idea. There weren't pros, there weren't cons. It was pretty evident that pushing the worst of the responsibility of the Planning Commission onto a new board, there's no win. There's no win in making those decisions, whether you shut down a bed and breakfast or not. You're gonna hurt some, other people are gonna be happy. It's a thankless task. So it seemed to me that this was something that could have been anticipated. I heard testimony talking about how hard it would be. So I was disappointed when it passed. I think it was all the reasons that this committee made it really difficult in that last group and self-perpetuated to have citizens not be able to do their own ballot initiatives because they said if you did not push it out far enough, you wouldn't get the understanding. So people said yes to this, but it's very difficult to implement. So I think it's a mistake. If you can fix it, I hope it can happen as was without having to wait 2 years and not be able to have anything get appealed.
Could you state your name for the record?
Oh, I'm sorry, I thought I did. Felicia Cowden, sorry.
Questions for the speaker? I'd just like to note that it didn't originate in this room. It was a proposal brought to the Charter Commission.
By the planning department. I consider this room as the planning department. So it came from within government.
It actually came from next door.
Next door. It didn't come from somebody out there who said, I don't want to go to the planning commission when I have a problem. We need a zoning board of appeals. It was the planning department trying to alleviate a challenge that they were having. It was not from the citizens, so I don't think anybody's going to be, feel betrayed. Thank you.
Thank you. Paula? If you'd state your name.
Paula Morikami, Boards and Commissions. I passed out to you today a letter from Mike Vahili, Director of Planning, and it basically states that it's very difficult to fill and we need to look at other options in how we handle these contested cases. I had a meeting with Manakea and Mike Vahili to discuss my difficulty in filling these positions. We need to find 7 members, and they told me it would take 16 to 20 hours a week. And so as I approached people to serve, I said, well, maybe at the beginning it would be 1 day a week, every Wednesday. We looked at the calendar of this room, every Wednesday from 8 to 4:30. And most likely it will be expanded as more contested cases are in front of the Zoning Board of Appeals. And it's very difficult to find anyone who will volunteer that much time, 1, 2, 3 days a week. And so this letter is from Mike Vahili, basically stating that he knows the concerns, he knows we're having difficulty filling these positions. And he's also discussed hearings officer, and that may be something that we internally need to look at in how to resolve these contested cases. But this letter is from Mike Vahili, so I just wanted to have it for the record.
Thank you. Questions for the Board of Commission Director?
Sorry, for the record, Monica Trask, I hate to impose, but I just want to say one more thing. This came up briefly. It came up at the last council meeting last week, and it'll probably come up some more regarding publication of charter amendments. So I just want to state and just clarify for the record. Under the Charter 24.03B, this is regarding process for amending the charter. It states, summaries of any new charter or amendment shall be published in a newspaper of general circulation within the county, and the entire text published by electronic or online publication on the official website of the County of Kauai, not more than 30 days after its adoption. So the only, there's some criticism that pros and cons on charter amendments aren't provided. And I just want to, I recall when I heard that at council, I recall that we don't provide pros and cons. And it's because I think it's inherently subjective and it may prejudice the record. So the charter clearly provides summaries. And we always torture ourselves, what is an appropriate summary? And so, just to put that out there, I understand some people would like to see pros and cons, or some people think that we're not doing enough to inform the public, but the charter calls for summaries, and I think the reason why is because if you are, pros could be, well, pros for one could be cons for the other, vice versa, and it may just, either way everyone's going to feel cheated, and so the summary is what it requires. Thank you.
Since this is a measure that was approved by the voters, and since the planning director, who recommended it in the first place and is now recommending it be withdrawn was not available today. I would urge the commission to consider deferring this so that it comes up on another meeting agenda. Any members of the public who may be interested can come and talk, and that we invite the planning director to come and address the commission about whether some of the facts around his decision making and whether there may be something else that can help solve the problem. It's clearly a problem within the county structure. So that would be my suggestion, but looking for a motion, members.
Move to defer.
Second?
Second.
Moved and second to defer. Discussion?
No discussion.
No discussion on motion to defer. All those in favor say aye.
Aye.
Opposed? Hearing none, that motion is deferred. It'll be back on our agenda next week. And Paula, if you would, next month, I'm sorry, if you would invite the planning director to participate, we'd appreciate it. The next item on the agenda is CRC 2017-07, a proposed, I'm sorry, 2017-06, a proposed charter amendment to amend Article 13 relating to the Department of Public Works, changing the title of the county engineer to Director of Public Works and changing the job description to reflect the title change. I understand that our Personnel Director has thoughts on this subject. If you'd state your name and give us the benefit of your wisdom.
Good afternoon, Janine Ropozo, Director of Human Resources. Our last county engineer was Larry Dill, and he left the county on February 15, 2015. Let me double check that. 16, sorry. So the position has been vacant for over a year right now. When he left, we did go out and try to attract people to apply for that position. We got 2 applications, one qualified and one did not. And so the mayor did not hire anyone right now. And right now we have Lyle Tabata, who is the acting county engineer in that position. He does not have a professional engineer's license, and therefore he is still occupying the deputy position, acting as the county engineer. We have historically had problems filling that position. We've historically also have had problems filling civil engineer positions that require the license that are civil servants. We have been on continuous recruitment for those types of positions for over 10 years now. And so the intent here is the administration is looking at possibly removing the requirement for a professional engineer's license for the county engineer position, or as we are proposing, the Director of Public Works now, and looking more for someone with leadership and managerial experience versus looking for the technical experience. We do have 3 divisions right now that already require a professional license. That would be the wastewater division in Public Works, the engineering division in Public Works, as well as the buildings division. So as far as having licensed engineers, we would already have that within the structure of Public Works. I did reach out to the various counties as far as what they have in their charters, and Maui County right now does not have the requirement, and their particular requirement is very generic. It's basically that the Director of Public Works shall have a minimum of 5 years of experience in an administrative capacity, either in public service or private business or both. And that's it. That's the requirement in Maui. Maui's charter does allow for the county council to augment those requirements. So they are looking at beefing up those requirements a bit by at least requiring a bachelor's degree as well, but it still would not require a professional engineer's license. The Big Island does have something similar to us right now, that they do require a professional engineer's license, but they have so far have been unable to fill that position. And when I reached out to the managing director there, he wanted to know what we were going to be doing, because he's thinking they may need to do that on the Big Island as well because they are having a hard time filling that position. The City and County of Honolulu, they actually reorganized in 1998. So they have a Department of Facilities Maintenance, which would be similar to our Public Works Division, minusing out the Design and Construction and Environmental Services. They do require a professional engineer's license, and they do not have a problem filling as the neighbor islands do. So they don't have a problem, and they're gonna leave it as is. So it's just something that we thought for consideration. Various administrations have had problems in filling this position, and so we'd like to see whether or not that would be something that could be considered in the next, for the charter to consider.
Thank you. Commissioners, questions?
Not that I'm opposed to the proposal, but my questions are, how does this change the responsibility of the county engineer, and how does it impact the financial pay of the position? I hope it commensurates with the change of time.
As far as the responsibilities, the only thing I think the county engineer would not be able to do would be to sign off on any types of plans that requires a PE
But
signature.
that's one of the problems I have, because they've been, in the past, through my experience, a lot of times the lower guys who have to process the paperwork, say with like reimbursements, federal reimbursements, all of that, they didn't want to sign the document just because they felt it wasn't kosher. So my problem is that what happens now? You know, is that takes away the responsibility, in my opinion.
So if we're gonna have someone else within the division signing the plans, those people could be reclassified to actually have that in their job description to have to do. And just for the record, all of the engineers, the professional engineers on staff right now, they all make more than the current county engineer's maximum.
Okay, and does the county pay for the licensing or relicensing requirements?
I believe we do. If it's a requirement of the job, we do pay for that.
Okay. So in other words, no one on the staff who's a licensed civil engineer who what you have they would get paid if you have to sign a document.
That would be something we could look at in the classification of the
Can you please
position,
check
if that's
on
gonna
that?
be an included
Can you please check on
requirement.
that? Then my second question, which I feel is equally as important, is right now the county engineer makes, I don't know, almost 90,000 or
I think the
100?
maximum is now 119.
Okay, so now, would this reduce the county engineers? If the title changes, would that position, the manager or director, get less than that?
The salaries are set by the salary commission, so that would be something they would need to consider whether or not the, not having to have the license would make a difference in where they
Yeah,
put them on the
because to me that is really important. To bring somebody up that high, that level, to me they need some qualification. And, while I'm not opposed to it, I still want to find out. Yeah, thank you. That's all the questions I have.
Thank you. Other members, questions? Go ahead.
It's more of a comment. In all my years working in the county and looking at the massive responsibility of the county engineer, I agree with Ms. Ropozo's assessment of that particular position as far as having a strong administrator, because the day-to-day workings from my experience in the county of public works is that there are so many moving parts that that person, that manager, that administrator is basically managing day-to-day operations, which should be because of all the number of departments and divisions under that person. And I found through the years, it was difficult to attract the talent and recruit and retain the talent in that engineering position. Because let's get real, the private market out there for a civil engineer makes much more than what we were paying at the county level. And Commissioner Watanabe, that is true. The salary commission will have to determine on that level. I think I wouldn't want to go there. So I would say at this point, and maybe more discussion is needed, I agree, we need to look at that particular position because of the amount of responsibility. And I want to defer to my colleague here, Commissioner Cockett, as a general manager, of a huge property, what his sense would be as far as all the moving parts, and you have to be on top of it. And you've got the technical people; they should know what to do, and you manage it. So it's more of a comment, and I just want to say to Mr. Ropozo that I agree. I'd like to have much more discussion on this. Thank you.
Thank you. I wanted to add, and thank you for the opportunity. Before I get into the question, I just had one other question, and that would be if we retitle the position to a managerial, administrative type position, knowing that there are other engineers in the system, does that in any way increase the opportunity for liability on the county? Because that person now is moved from that position, is moved from a engineer to an administrator. However, it has the responsibility of signing off on, I don't know, massive projects, I believe. So that was just a question that I had. Going back to the comment, I think that, just in my experience, I think if you have adequate people with the right skill set in the engineer position, thank you. I think if you have the right people with the right skill set surrounding that position, I don't think it would be a problem. I think the manager or the administrator of that department would be able to handle the day-to-day operation and oversee the operation itself. I think for me though, when it comes down to the technical aspect of it, I don't know if someone that can leadership and management is great, but having the technical skills to understand it as well, right? In my experience, and probably some others as well, we'll take a small thing, maybe like pools, right? There's a lot of technical things with pools, and you have to balance, and there's a lot of guidelines and OSHA guidelines, federal guidelines that you have to follow. So I'm not sure if this person that would oversee that department as a leader, manager, administrator, without the technical skill, if he would be the person. But if there's adequate people around him supporting him, I would be supportive of that.
So back to the question on the liability, I think what we would do is need to look in the charter as far as what responsibilities require the license and what don't. And if we're gonna move that to the actual division chiefs as for their responsibility, as far as for signing off documents, if it doesn't require a license, of course, the director of public works or county engineer, whatever we're gonna call this person, would still have that responsibility and liability. There's gonna be a lot of moving parts to look at exactly how that would work, but I think think Maui already has it in their charter. I think that would be a really great place to start as far as seeing what has happened with their department. I did ask the HR director there if they've run into any kind of problems, and he said, no, it's working fine. So I just wanted to check whether or not we're going into something that, there's already problems with.
Sure.
Other comments?
No, just how long has Maui been doing it, made a change?
I don't have that.
You don't have that.
My view with regard to Commissioner Watanabe's thoughts on pay is that this is one of the biggest departments in the county, and I'm not sure that I'd recommend the salary commission make any downward adjustment. It's a big job regardless. I suspect that the person in that position, judging in part from the fact that that he has subordinates who are making more than the head of the department, that position may now be paid too low. But I'd love to, since he happens to still be on the island, to get Larry Dill in here to give us some thoughts at our next meeting on just how much his engineering and how much his administrative capacities played a role in doing that job, because this is a pretty big change for the county. And it sounded like you might want to play a little, take a look at the language, take a look at the charter, to see how the different pieces work together. My suggestion would be that we defer this at this time and gather a little more information, let the county make sure that we have a seamless proposal before we take it up. But before we go further, before we take a motion, any further discussion, any
I
further
have one
questions?
more,
Go
Mr.
ahead.
Chair. I don't know if you've noticed within the last 4 months, but the Department of Parks and Recreation took almost the whole maintenance staff from the county engineer. They're not on the public works anymore. So, in regards to your statement, I think maybe we should ask Ms. Ropozo to look into that also.
They are still the largest department, but they were larger.
Yeah, right.
They Parks and Recreation, actually, a lot of it came on, I think all of it came off of Public Works, and then now the maintenance also went over. So they have been shrinking. Most of now what they have is the engineering type of departments. They do still have the auto maintenance shop, which is really nothing to do with engineering, but other than that, recreation went over, maintenance went over.
Yeah, but I don't think Parks gained any employees to handle the transition.
As far as when maintenance went over?
Yes.
Yes, you are correct.
And no extra money either. I don't think.
No, it was just seamless, just
Okay.
the whole thing just transitioned.
Mr. Ropozo, in your opinion, why is it difficult to attract a county engineer?
Well, let's take Larry Dill, for example. He basically moved to a civil service position in the state. He's got security now. He's got, basically not having to go in front of council. It's just a lot of different things like that. A lot of our engineers are attracted by the private sector. So the actual, if you're a county engineer and you're registered a professional engineer right now, you're kind of a hot commodity. And to come to the county to be for a 4-year stint, let's say for the coterminous with the mayor, may not be as attractive as going to something that's civil service that you're going to be there, security wise. It's a very different kind of thing. It's a heavy responsibility to be that county engineer. You've got the public calling you all the time, what about this, what about this? You've got council also calling you, you've got the mayor, So it takes, I mean, somebody who really wants to do public service is something that, that's the first thing. And then it's not like, you know, the pay is something that's going to be more, so that's why you're going to come. It's probably less than what you could get out there. So it's been difficult. And especially now when Larry left kind of midterm, you basically can only offer a new person. You know, at that time it was 2 years. And then after that, there's no security. So it's kind of something that people have to really consider if they want to do or not.
Thank you.
Other questions? If not, thank you, Ms. Ropozo. Members of the public? No, hearing none. Can I get a motion?
Move to defer
Second.
Motion is to defer.
and have Larry Deal attend the next meeting if possible. Thank you.
Paula, could you ask Larry whether he'll consider, and Janine, if you'd consider coming back with whatever adjustments you have to the proposal, we'd love to see it. Thank you. All those in favor say aye.
Aye.
Opposed? Motion is deferred. Next item is CRC 2017-07, the proposed charter amendment to remove Article 32 relating to the county auditor. Do we have anybody here who wants to talk about that? County attorney? Love to hear.
Hello, for the record, County Attorney Mike Trask. I did offer to be present.
Thank you.
Thank you.
Sorry.
No, it was, you know, when we were going through the charter a year or so ago on another matter, I had the opportunity to learn a lot about the county history. And so I was able to read commission minutes from, I believe, 65, 66, 66, 67, and 67, 68, or thereabouts. So I understand how these all things happened. And the charter amendment to bring back the county auditor after it had gotten rid of in the late 60s, which happened right before me, but I've learned about that too. And so if you have any questions regarding that issue, I'm happy to answer them too.
My question, this was just on the ballot, right?
No, this is
A while ago.
It was a while ago?
Yeah,
Oh,
and my recollection, and this is another case where I think we ought to have the county council is the employer of the county auditor, and I think we ought to hear from the county council on this subject, but my recollection is that it was established a number of years ago. An auditor was put in place for a period of time, the position has been vacant for some time, and the council has either not chosen to or been unable to, I'm not sure what the details are, to fill the position, so it's been vacant for some time. And I don't have particular thoughts one way or another on this, but I'd love to hear from the council.
So real briefly, prior to the County of Kauai promulgating a charter, the territorial legislature provided for the way the government was supposed to be in the various counties. And up until the late 50s, that's how it was. The legislature approved the first charter for the seat in County of Honolulu, I think in '59. And that became the model for all the other counties. And then there was the territorial legislature, or at the time the state legislature, let's see, appropriated, no, that's not the right word. They gave about $1 million to conduct a study with the Public Administrative Services, PAS, and that was an organization, I think from Chicago at the time. And they did this comprehensive study. It's very interesting about government in Hawaii. And they talked about what's the best way to create county government in this new state of Hawaii. And so in the territorial times, the Board of Supervisors was the power, and the chair of the Board of Supervisors was like a titular mayor. No real executive authority, but it's largely ceremonial. They did certain things. So if you read the charter, but at the same time the county attorney was elected, the county auditor was elected. Board of Supervisors were elected. There's some other, I think the prosecutor was appointed actually, but I'll just leave it at that. I'll speak to what I'm sure of. And if you read the minutes, the charter commissions, although there were 3 different commissions, they all kind of agreed that the auditor, who was an elected position, was actually nothing more than a ministerial position. The auditor signed the checks, the auditor did audits, but it wasn't like a policy-making person. And therefore, as we're moving into this dual branches of government system, kind of like a county level checks and balances, you have an executive authority, and even the Board of Supervisor chairman at the time complained, hey, the Board of Supervisors, the council, shouldn't have any executive authority. You know, the mayor should do the mayor executive, the council should do legislative, and if you conflate the two, it just doesn't make any sense. You know, you don't get time. And really, you read those minutes, you're seeing how our county was created. It's a really interesting read. But essentially, they got rid of the county auditor. They thought it'd be better to create the director of finance, who has plenary audit authority within the county COI right now. If you read the director of finance's authority, he or she can audit any and all departments at any time, both financial and performance audits. That was thought to be best under an elected executive, a strong mayor, who could then, because that was an executive business. Later on in the mid-early 2000s, I think 06 or 07, the idea came up that the council should have an auditor position, and the council could then audit check the executive. But then if you look at it, I think it was kind of sold in that way. But currently under the charter, it is required that you have to have an outside audit firm come in and do an independent financial audit every year anyway. And then you have the director of finance having plenary audit authority, and now you have a county auditor doing audit authority. And so what do you have right now? Well, you have the potential for, of course, an unbiased outside audit, which I think is the most credible. We could all agree to that. And then you have 2 separate branches of the government potentially having somebody who can audit the other branch and just create a bunch of political turmoil. And if one thing I've learned working here is that people are best served when everyone works together, not when they fight. And Chair is right. I think the county auditor that was hired is no longer with us. I understand they never had an audit certification. They weren't a certified auditor. They were a CPA. And so the auditor only contracted out for audits to be done. And so I think, again, you had a well-intentioned idea that never really materialized. And now I am aware that the council cannot fill this position just because it doesn't pay enough. The skill set is not on the island. You have to pay people to move here from other places. And again, it's such a potentially powerful, you know, and audits can be very, you know, they can be very intrusive. People don't really look fondly upon them. And there's a bunch of concern, even if they could find someone to work for so little, how that would happen, you know. And so to this day, we still don't have a county auditor. The auditor's office doesn't exist. There are no employees. Nonetheless, though, audits are very important. Audits still happen every year. So it's not like getting rid of this office would mean no audits. The charter requires it. So the thing is, how many redundancies do you need, and is it good to have these types of competing abilities and interests? So that's the question.
Questions for the county attorney?
Yeah, just to add to what you said so far, Mr. County Attorney, we've spent on this new amended auditor system since 2009, $7.2 million. Wow. Almost $7.3 million for 19 audits, and 8 of those audits were already being done by the county clerk's office, contracted them out. And it was just a monitor team. And the same thing when it turned over to the county auditor. They just monitored the contracts, they just put it out. So, you know, to me, there's a lot of money to spend on 19 audits when 8 of those audits already were being done from many moons ago. The county clerk's office always had that responsibility. And so it comes out to approximately $383,000 per audit. So that's why I felt that, and it's been vacant at least over almost 3 years now. And even the staff that was left after the county auditor left, none of them were qualified to be the county auditor per the charter. You know, so that kind of goes along with what you said. It's hard to find someone qualified.
And that's the real argument to be had. So when you look at this going forward, I mean, numbers, they're not going to lie in that regard. And so I'd just like to say, I got my email, I think last week, NPK are making their yearly annual visit, so I owe them a bunch of reports. So it's happening.
But just for history, wasn't the county auditor something that the county council recommended? Yeah.
2008.
And so maybe if we're gonna defer it for further discussion, maybe you can get some input from the council.
Yeah, I would ask as many members of the council as choose to, invite them to come and talk to us about whether they think this is a good idea. Clearly, the county council has its own authority to put items on the ballot. But if for one reason or another, because they view it as a conflict, they think we ought to consider it, that's our job. But, yeah, so any further questions for Mauna Kea?
Yeah, the council has it authority under Article 3.12,
Yeah.
Section 3.12, which is under the county council for both performance and capture.
Yeah.
Comprehensive.
Okay, thank you, Mauna Kea. Members of the public? Felicia?
Felicia Cowden for the record, and I know Ernie Passion, many times his name comes up repeatedly. I appreciate what Mr. Watanabe shared, a profound amount of money being spent there. My recommendation is that there would be a deferral on this, not only to be bringing in the council, but many of the issues that come before this commission really need to bring in the public. And what we hear routinely is people who question the integrity of one branch of the government or the other branch of the government. And when I hear it commonly, it is intergovernmental issues coming back and forth. It's like a family fight to some degree. But I think that this isn't a decision that should be made without the public being aware of it. It's not minor, and even just in the way it sounds, if we don't have cross-auditing. I appreciate that Mr. Watanabe said that the county clerk effectively audits that. I think that it's really important to have that brought out to the public in a very clear way, because it seems that in council, there's always a lot of questioning of how the administration is spending their money. And if the county clerk is doing the audit, I would think that they could just say, well, this is what our audit shows. So I support a deferment, but not just to ask the council, but to try and get it out somewhat to the people, because I don't believe I've ever met Ernie, but how many times I've heard his name come up again and again and again. And there were people that he subcontracted that I do run into who are profoundly opinionated on what they feel that they saw. And I think that, like, when you're putting it out for what kind of people can fill these positions, there might be retirees or people who aren't really that deep into the workforce who might be able to do it for less than what you're saying. That's an incredible amount of money to have been spent for duplicate work. Thank you.
Just a clarification.
Sure.
You stated, what I meant to say was the county clerks oversaw the comprehensive audits in the past, before we started this amended version of the charter. Okay, just a clarification.
Okay, thank
Okay.
you.
Thank you. If not, can we get a motion?
Move to defer and invite the county council or members of the council to attend perhaps our next meeting, if possible.
Second.
Moved and seconded to defer. All those in favor say aye.
Aye.
Opposed? Item is deferred, and staff, if you would invite the chair and members of the county council if they so choose. We can't dictate if they choose to come or not come, but love to have them here to talk about this. That ends our current agenda. Did members of the Charter Commission have any other items that we can't discuss items beyond those on the budget, but if you bring up an item now, we can put it on the budget for the next meeting?
Agenda.
On the agenda.
On the agenda, I'm sorry.
Mr. Chair, you know, can I go back to one, and I just have proposal CRC 2017-05, which has to do with the removal of the zoning board of appeals. You know, the planning director and the planning department, as was told, is using another process in reviewing the appeals. Sometimes instead of removing, maybe they can use new verbiage for the process that they are using. And I think the public is more apt to accept new verbiage rather than removal.
I'm hoping we can have that conversation with the planning director about whether there's another way to solve this problem.
Option.
So
Yeah,
perhaps
and
that's
what
a
other options there might
question
be.
that can be
Yeah.
posed.
Thank you very much. Good point. Other items? Otherwise?
Chair, there
Yes,
was a
ma'am.
handout that was
Yeah.
given to us. Is that out of part of the agenda, but I'm just wondering, Adam, is this from you, Adam, or?
I think this handout was provided by the folks at boards and commissions, and it is essentially a copy of the same document that the commission was given in the last meeting. It's a summary of all of the charter amendments since 1972. I think it's just organized in a different manner to make it, and color-coded, to make it simpler to
I
understand.
kind of asked for a little bit more clarification on that at the last meeting. Okay, so this is what this is. Thank you.
Yeah, I'm gonna get with, Chair, I'm gonna get with, boards and commissions and, try to look at, the supplemental budget submittal by the mayor. And, the necessity of having a public hearing on the day that we pass the budget in final. I don't think it's, makes any sense.
If you're
Not
thinking
we,
is that
not
if
we,
you,
I mean
if
the
they,
council.
well, we can't talk about that.
Yeah,
but
yeah.
I'd be happy to,
But that's
if you would
upcoming.
talk to the
I will,
staff
I will.
and then have them or you get a hold of me within
2 weeks.
within 2 weeks or so we have time to put it on the agenda,
I will.
and it'll be an agenda item at the next meeting.
Okay, so Chair, by stating our opinion or for the next agenda item, for example, I would like to revisit the idea of a four-year council term limit or term process. Do we just say it today's meeting, or we just call the boards and commission and let them know that we'd like to have that in the
Either
agenda?
send, if it's convenient for you, send me an email or send
send
Paula an
emails.
email and have her, the chair is in charge of the agenda.
Okay.
So, I'm happy to put something on the agenda, so if you have thoughts from this document that have come up before that you'd like to discuss again,
Right.
let's get it on the agenda.
Okay.
And we can review it, and we'll be able to do it in the presence, let's hope, of a full panel of 7 Charter Commission members. Anything further?
Move to adjourn.
I have something I would like to say.
It's out of order, but come on, go ahead.
Felicia Cowden for the record. I have a real issue with the transparency of this commission. I believe that this should, for how important this is, to be able to adjust the charter, and for people who don't know what that means, that is like the constitution for the state or the federal government. And so when we have a quorum of 5, that takes 3 people to make a decision. And there is 4? Okay, so we need 4 people to make a decision. And these are decisions that are very deep. And there is such a weak level of public outreach for what this is. You have to be very wonkish, I might say guilty on that one. You have to go to the county website, look under this, find it 6 days ahead of time, read something sideways, because they don't even put the minutes upright. You have to turn your head and move it to look at that. There's, for the amount of importance that's in here, and there is beyond not public outreach, this is almost behind closed doors. I am the only member of the public that's in here today. And I have to bring a camera in here to feel confident that I'm going to be able to be treated respectfully. It hasn't been this group, but it certainly has been in the past, that it doesn't have this. And there really isn't, like you can't send something to Charter Review Commission at Kauai.gov. It says mail in your interests, and you can't even see what's on the agenda till 6 days ahead of time. You know, there is hurdle after hurdle after hurdle. And the type of things that this commission has in front of it, the county council would have a battle for a year to be able to pass. And this can happen in here in 3 meetings. And I know I have multiple times had pieces that I would like to see as a charter amendment, and it does not matter how many times as a citizen that I bring it up, there is no room. There's not even an agenda item for public testimony. I had to ask to come and speak. There should be a space on the agenda for a person to be able to come and say what is important to them, and it is not available there. And many of us are actually quite aware of the charter. And I feel like this is an end game around democracy, that we have this commission, especially when it does not work out towards the public the way it was intended. And when this was picked, when it was made by Brian Baptiste, it was like his close friend. And this was intended to be something like the general plan update, where we look to the public to be able to say what we want and what they want. It was not intended to be a very closed, quiet piece where the members to come on the charter, the commission, are handpicked. You guys are probably the most competent or most capable that has been picked there, but it's nerve-wracking to see it. And I can't tell you how deeply it disappoints me and depresses me that the county would do something like have this and have so little public input, and to where it is not welcome or wanted. And what you're doing is so important. And there are critical areas that need correcting. And it is not up to the public to be able to come in. One has to be aggressive and uncomfortable to come in and participate. It deeply saddens me. Thank you.
Thank you. Felicia,
Yes.
our next meeting is on November 27th. So, it's more than 6 days notice.
I know when it is, but it doesn't publish the agenda. You don't see the minutes of the last time. And I have applied for this commission many times because I want to be a voice of the public, and I am never responded. And then I know I have brought somebody here who didn't even know what the charter was, and I brought them in to see, and he was invited onto the commission in that meeting. by you, Jan. So it is an inside group, and it needs to be something that's up and open. Thank you.
Thank you, Mr. County Attorney.
For the record, Monica Trask, County Attorney. Felicia, is that on?
Yes?
Okay, good. So I just want to state this for the record. You know, charter commissions they're a product of, like I talked about in the history. So the territorial legislation provided for them in the early 60s in order to create charters for the counties. And I just got to say that I understand how a lot of people take, and I know Felicia, we're friendly, I consider her a friend, I respect her, she's definitely a voice for her community, she has a radio show, she's very vocal at council meetings, and she serves on many commissions, and I appreciate hearing her mana'o, and definitely anyone who cares enough in a democracy to participate should be applauded. But for the record, the commissions, all commissions provide the requisite legal requirement for notice. For the chair, Tim Brugengate, for those of you who have participated as chairs of various commissions, you produce these agendas. Often you don't know yourself what's going to be on the next commission until 6 days before. You get your materials, you put them on the agenda. I don't think it's an accurate statement to say that there's anything unethical going on or there's a deliberate conspiracy to disinform the people of Kauai. I am the county attorney. I do everything I can to educate my friends. And ultimately, I cannot agree, and I just want to clarify the record, I don't think, in my professional capacity as a public official, that this is an inside group or there's anything inappropriate going on. If you are doing that, I would advise you not to do that. And if I knew that it was going on, I would be ethically obligated to ensure that it stopped and that corrective action would be taken, including your removal and anyone's removal from a board or commission or office, elected or appointed, no matter what. And I'm telling you that right now. Ultimately, I think, and I know it's not I think, it's a fact that I'm glad Felicia's over here. I'm glad we can't afford, it's not in the budget to have another $20,000 to have this recorded by BC and Hawaii or whoever does that stuff. I wish we had all the money to film all our commissions. We don't. But ultimately, responsibility in any democracy and what makes it such a good form of government is within the people. You know, people do need to show up, and not just for the sexy, fun issues. You know, for all the issues, they need to show up to work and get that job done. I myself, I got a legal education. I didn't know anything about the charter. I never took it upon myself to learn. And now that I do know, I'm really glad, and I try to tell as much people as you can. So, and I think it's unfortunate that civics are lacking. My kids don't know anything about student government. They don't learn about it in school. They should. So I just want to clarify that for the record. I don't get off my soapbox right now, but I just want to stay clear for the camera that to my knowledge, nothing of that sort is going on. And thank you for your service. You're not getting paid. So, triple thank you.
Thank you. If I could take a little executive privilege, just a couple of points. In my view, this commission is the very exercise of democracy rather than an end run around democracy. Brian Baptiste did not establish the previous charter commission. The people of Kauai did. They voted in an election, and the majority said establish a 10-year charter commission, and one was established. It was the voice of the people that did that. The charter commissioners are nominated by the mayor, who is elected by the people, and the charter commissioners are confirmed by the county council, whose members are elected by the people. And we serve at the will of the people ultimately. There have been some suggestions that decisions are made by less than a quorum. That doesn't happen. It requires 4 votes. The majority of the full appointed number of members of a commission, no matter how many are present. We meet at public locations. Our meeting places are regularly noticed. We have staff present, the lights are on. And I have on multiple occasions at this meeting invited members of the public to come up and speak. And I hope that kind of transparency continues, certainly will through my term and through the term of anyone who follows me as chairman of this commission. Thank you very much. We have a motion, unless there's anyone else. We have a motion to adjourn.
Before you adjourn.
Oh, the next meeting has previously been announced. The next meeting is at 4 o'clock on November 27th, a Monday, in this room. Did I have a second for the motion to adjourn?
A second.
The motion.
Who made the motion?
I did.
Ricky made the motion. Moved and seconded. All those in favor say aye.
Aye.
Opposed? We are adjourned. Thank you. Thanks.